Senator Claire McCaskill hosts the last of several roundtable discussions aimed at combating rape and sexual assaults on college campuses. This meeting focuses on the differences between the criminal justice system and the university-based process. It's 2 hours, 15 minutes.
Good afternoon, everyone. Since we have a lot of ground to cover and a lot of smart people around this table, I'm going to go ahead and get started, and I know that Senator Blumenthal will be joining us, and when he does, I might interrupt whoever is talking at that point and give him a chance to make a few opening remarks when he arrives. First, I want to welcome all of you that are here today. I'm very excited about this particular roundtable because of my background as a sex crimes prosecutor for many years. This is the last in our series of 3 roundtables, which are discussions about sexual violence on college campuses and university campuses. This has been a terrific process and also a very helpful one. On May 19th, we had a really good discussion on the Clary Act and the Campus Save Act. On June 2nd, we had a thought-provoking and intense discussion about the role of Title IX. I wanted to hold these roundtables so that we could bring people together rather than having all of the university officials at one and all of the police at one and all of the victim survivors and advocacy groups at one. I wanted to mix each one so we could get the discussion back and forth, which I think has been really helpful in us finding where really there are points that we can move on in terms of making improvements and changes and holding out best practices to other campuses. We can't make good policy choices if we don't really know what's happening on the ground. These discussions have been very helpful in informing my Senate colleagues and I as we work on legislation, and I know that today's roundtable will also contribute to that effort. This topic is very near and dear to me, today's roundtable. As a former prosecutor, I have been on the front lines of the fight against sexual assault. I want to do everything possible to make sure that these crimes are prosecuted and that the perpetrators of these crimes are held responsible to the fullest extent of the law. But as a former prosecutor and a former lawmaker at the state level, I know that our criminal justice system and the laws that support it are not always perfect. And they hasn't been willing or able to handle many sexual assault cases, particularly cases involving consent as a defense. And especially when there may have been intoxication, in fact, the fact pattern that we see most frequently on college campuses. Even law enforcement and prosecutors have been known to fall into stereotypes about what quote-unquote rape is supposed to look like. Educational institutions have a role to play here, too. They have a commitment to their students and their community, and when incidents of sexual violence happen, they have an obligation to investigate what happened, support the survivor, ensure a safe campus for all students, and if the facts bear it out, punish the offender for violating the school's code of conduct. The problem is colleges and universities haven't always done that. They may have ignored the problem, swept it under the rug, and hoped the survivor would give up and go away. Many schools are working to improve their administrative procedures and be more responsive, but we know there's room to do better. In my many conversations with survivors, I have heard again and again how both systems have failed, to the point where it appears many survivors have little or no confidence in either the criminal justice system or the administrative process in their own colleges and universities. I hope we can talk today about how to ensure that both processes work better, support victims, and hold perpetrators accountable. There is also a need for these two systems, the administrative system and the criminal justice system, to work together. I think there might be a perception that they can't work together because they have different responsibilities and obligations, which is true in some sense, but these two systems also share a common goal, which is support and justice for the survivor. In fact, the White House Task Force is recommending that universities and local law enforcement enter into memorandums of understanding so they can build stronger and better relationships working together. I know we have some organizations here today that are already working together, and I look forward to learning more from you. Now, if you would, go around the table and introduce yourself and tell us briefly where you're from and what role you play in this discussion. And then we will begin a series of areas that we'll talk about. I will caution, we have a lot of people on the round table today, and a lot of you know a lot. And there is going to want to be, I'm going to do my best to be not like a senator and talk, I'll try to talk less frequently. I will try to be unsenatorial. Here's this is Senator Blumenthal. Before we begin introducing, Senator, would you like to make any opening comments?
Well, I caught the tail end of what you were saying about saying less rather than more, which I think is exactly the right approach. We're here to listen, and I, first of all, want to thank you, Senator McCaskill, for bringing together yet another really stellar, highly qualified group of people to enlighten us. And I want to thank all of you for coming, particularly Darcy Folsom from the University of Connecticut, and you will hear her story from herself, but it's very impressive, and I know each of you have an impressive contribution to make, so just thank you for being here. I know it's not easy to get here, just having gotten off a flight myself, but thank you for making the trip and the effort, and most important, for all your great work, all the work that you're doing on your campuses, in your states and localities, and law enforcement, for both of us, is our first career, I would say, and so we particularly welcome you. Thanks so much.
Thank you, Senator Blumenthal, and I want to also say that my job today is to move the discussion along and make sure that everybody has a chance to share, but I also want this to be very informal. We've found that the previous roundtables worked so well because it wasn't just a typical hearing where senators are asking prepared questions and witnesses are trying to give answers, but usually not complete ones. So we want this to be free-flowing. We want you to feel free to jump in if someone's making a point that you think you can add to or augment. But we also want to hear from everyone. So to some extent, I will be kind of corralling everyone, and not that I would ever want to cut anybody off, but we want to make sure that all voices are heard from. So let's start.
And I just want to correct did I say University of Connecticut? I meant Connecticut College, sorry.
Big difference.
That would be a cardinal sin.
That's right. That would be like me saying Mike was from a zoo. I wouldn't do that, Mike. He's a bear. He's not a tiger. Okay, let's go around the table and introduce everyone.
Good afternoon. Thank you. It's my pleasure to be here this afternoon. My name is Katarina Booth. I am a Chief Trial Deputy with the Boulder County District Attorney's Office. That's Boulder, Colorado. In that capacity, I work as both the supervisor of the unit, which handles all of our felony domestic violence and felony sexual assault crimes that are committed within the 20th Judicial District. I'm also I'm a hands-on prosecutor. I'm still in the fight with a heavy and active caseload of our felony sexual assaults. And I also serve as a supervisor acting on many of the committees working with our university partners. So from our multidisciplinary committees, our agencies approach and try to make that collaborative effort and outreach to our universities so that we can work together on prosecuting crimes of sexual assault. Thank you.
Great. Good afternoon. My name is Becca O'Connor, and I'm the Vice President for Public Policy at the Rape, Abuse, and Incest National Network, or RAIN. RAIN, for 20 years, has worked to inform the conversation about sexual violence. We do so through public education. Pointedly, we work with college campuses across the country. We empower students through an annual day of action to bring awareness to this issue. And we also have worked heavily in the space of public policy. And we run the National Sexual Assault Hotline, which to date has helped more than 2 million people.
Great.
Good afternoon. My name is Jennifer Gaffney. I'm the Deputy Chief of the Sex Crimes Unit in the New York County District Attorney's Office. Thank you so much for having me and for all of the attention you've paid to this issue. In our office, the Sex Crimes Unit handles all of the sexual assault prosecutions of victims age 14 and over, as well as some sex trafficking prosecutions and our sex offender registry. In my capacity as a Deputy Chief, I supervise our assistants on those cases. I, too, have a caseload of my own, and I participate in our multidisciplinary task force and do outside trainings to different groups, including advocacy groups, college groups, safe examiners, etc.
Good afternoon. Thank you for having me. I'm Detective Carrie Hull from the Ashland, Oregon Police Department. I am an active detective in that agency. My primary caseload is adult sexual assault crimes and then child sexual assault crimes, though we are all general crimes detectives. I also sit on the Legislative and Public Policy Committee for the Oregon Sexual Assault Task Force, and am a law enforcement instructor for their training institute, as well as a forensic interviewer of children.
Hi, thank you so much for inviting me to join this conversation today. I'm Alexandra Brodsky. I'm a student at Yale Law School and one of the founding co-directors of Know Your Nine. Know Your Nine is a grassroots, student-driven national campaign to end campus sexual violence. Toward that end, we work to make sure our fellow students across the country are aware of their civil right to an education free from violence, and also advocate for better federal enforcement of that right.
I first want to thank you, Senator, for all your support around the issues of sexual assault. I'm Jessica Ladd-Wiebert. I'm the director of the Office of Victim Assistance, which is at the University of Colorado Boulder. We're a free and confidential counseling and advocacy center. We are therapists and advocates who help people who have been impacted by a variety of crimes, with sexual assault being one of our topic areas we focus on the most. And we're here to make sure that our clients are empowered and informed when something like this happens.
Good afternoon, Senator. Thank you very much for the invitation to participate today. My name is Paul Denton. I'm the Chief of Police for the University Police Division at The Ohio State University, Ohio's flagship land-grant institution of higher education. I've held this position for 8 years now, and 28 years prior to that I served at the Columbus Division of Police. I've experienced both in municipal law enforcement at large agency and at campus policing now. Recently, I served with some of the colleagues here on the Negotiated Rulemaking Committee as an alternate. They have full voice in that process. The recent rules that were released related to VAWA. And I'm an appointed commission member for the Ohio Peace Officers Training Commission.
Thank you, Chief.
Hi, and I echo my colleagues' sentiments of being invited to the roundtable, and we look forward to working together to inform legislative writing and policy changes in these areas. I'm Kathy Zoner. I'm the Chief of Police at Cornell University. My office holds a primary Clery statistical gathering as well as reporting, create the annual security report. We work with the Title IX coordinators whenever possible and as aligned with to help with their investigations. I convene our Public Safety Advisory Committee, which keeps us in compliance with New York State Education Law, Article 129A, which is a prime example, I think, of a well-intended, over-legislated directive. We also, on campus, our president created a Council for Sexual Violence Prevention that we would think better speaks to what the intent of Article 129A was, which is collaborative work across genders, across sexuality, and in the efforts of rape education and prevention. I've served on the Campus and Codes and Judicial Committee, which was charged with aligning our code with OCR's recommendations, guidances, as well as its mandates. I also chair the Human Resources and Safety Services Diversity Committee, which is charged with creating a more welcoming environment for all aspects and all walks of life on campus. Also, in my iteration, I started 23 years ago, all with Cornell University as a dispatcher, and through that time frame was elected to the board of directors at the then Ithaca Rape Crisis and served there for over 12 years. 9 of those years were as the board president. So I think in order to emphasize my passion for this subject matter, I can't emphasize it enough. So thank you very much for the invitation.
Thank you.
Thank you for having me. I'm Darcy Folsom. I'm the Director of Sexual Violence Prevention and Advocacy at Connecticut College, which is a small private liberal arts school in New London. And we are an OVW campus grant success story. You know, we had the grant from 2010 till 2013, and the campus administration really saw the success of the program and the work that we were doing on campus and saw the value and continue to fund the program as well as my budget. And so we have instituted Green Dot, which is a bystander intervention program that's a national program, which has seen a lot of success at Connecticut College. And with widespread student buy-in, I think that we've got a really solid program to talk about.
Thank you, Senators. I add my thanks to everyone. My name's Nancy Cantalupo, and I have been working on this issue for nearly 20 years from various perspectives. I started out as a student activist and then became a Women's Center director at the same institution, Georgetown University, and later became, after I spent some time in practice as a lawyer, went back to Georgetown Law as an assistant dean and began volunteering to act as faculty counsel to students who were accusing other students of sexual violence through the student disciplinary system. So I have litigated administrative proceedings under Title IX and the Clery Act. And those experiences led me to start researching and writing in this area. So I have now authored 7 articles on Title IX and the Clery Act and the case law that applies to accused students' rights in civil court, so their administrative due process rights, and have continued in this work in various ways, including being a negotiated rulemaking participant, now finishing up with continuing as a researcher at Georgetown Law, but also having a position as a research fellow with the Victim Rights Law Center.
Senators, my name is Mike Youngers. I'm Dean of Students at Missouri State University, and it's my pleasure to be here. My role at the university as Dean of Students, I'm responsible for our behavioral intervention team, another group that I bring together, campus safety group. I'm tasked with not only the prevention and education program around sexual violence, but I also am responsible for student conduct on our campus, so our conduct process is under my guidance. And I've been in higher education quite a long time and in student conduct, so that I've seen from when I was in school and there was no student conduct process, the many different alliterations to where we are today, and I'm frankly excited about where we're moving.
Great. Well, that's terrific. So I will start with one area and then I'll trade off with Senator Blumenthal, and hopefully we'll get through all of this within the next couple of hours. We have learned that most schools don't have written protocols between campus law enforcement and local law enforcement. And maybe, Chief Denton, you're the best one to start off here since you've been in both worlds. I don't need to tell you that it's not always a bed of roses between local law enforcement and campus law enforcement. I've seen those two groups work together well, and frankly, I've seen them behave badly, where one is dismissive of the other, where there is some territorial, inappropriate behavior. And I would like your take on what we should do, how we can do a better job, and you should start, and anybody else can jump in, certainly Chief Zoner and any of the others, the detective. I mean, one of my fears here is we are having way too many interviews of sexual assault victims that are not being conducted by someone who knows how to do a forensic interview. And I think the detective will tell you that, and the prosecutors will tell you that in a lot of cases, the difference between holding someone accountable sometimes has more to do with how the victim is interviewed than the underlying facts of the case. And so in a perfect world, I would have someone on every college campus who was the very first person to talk to a victim when a victim is willing to talk, make sure that every single one of those people had been trained in a forensic interview technique as it relates to a sexual assault crime. But tell me your sense of how well you all are working with local law enforcement, and you may be an anomaly because you've come from their department. And many times you don't have that. So you don't have that kind of, you have relationships there, I'm sure, that assist you in terms of keeping a working relationship. Why don't you speak to that?
That does help, Senator. to speak to the professionalism of campus law enforcement agencies, I'm a very big advocate of accreditation efforts, either through the CALEA accreditation or IACLEA accreditation. We recently achieved that at our agency, and that is a very defined and specific process where agencies have to create policies, procedures to address everything from clery compliance to response to investigations and cases. Fundamentally, so that's how I think you build that relationship in one by increasing your professionalism. Central Ohio, we probably are very, very fortunate. People I've come up through the ranks with, people I've worked with, known them professionally for 25, 30 years, are now heads of agencies, so we do have very good working relationships, and I'm fortunate for that. In terms of response to crimes, I think it's basic and fundamental police service. When we get a call, request service from us, I expect the very basics on every crime as much as possible, whether that's locating a crime scene, collecting evidence, conducting and identifying interviews when you identify witnesses so you don't, we have to re-interview victims or survivors multiple times. It's fundamental police work in many, many cases, and then you can proceed with that case in the courts as you would any other case.
What do you think is preventing strong working relationships between police departments? For those of you that have seen the side of this that is not as good, what is preventing good, strong working relationships between campus police and local police?
Well, I can address some of that. We have a really great relationship with Southern Oregon University that's within our jurisdiction. Now, our department is a little unique, maybe different from some here, where they don't have sworn law enforcement, so our municipal law enforcement would take the case if it was a sexual assault anyway. However, you still have to have that working relationships because oftentimes a victim may present to a campus public safety officer. So you still need all that same training there. We have found that it needs to be an open line of communication for training. Training is incredibly important with a clear understanding, and again, our department is a little bit different. We have what's called the You Have Options program that was developed to increase sexual assault reporting within our city. And then the other side of that program was by increasing reporting, we're increasing intelligence on serial sexual offenders for law enforcement. That absolutely, the foundation of that program is in confidentiality. So that is, with Title IX, we then have to be very cautious about information that we share with the university that would trigger a Title IX investigation. So you'll actually see a flip, maybe, from what you've heard in previous roundtables, and that our municipal law enforcement agency has to be cautious of what we provide to a university. Now, the intent is always still there, though, to share information, to collaborate, because it is much better for the survivor, ultimately, if we want to go forward with anything, to have that collaboration there. But what I would like to enter in for everybody as a starting point is that it's always at the victim's request and with the victim's permission. And we found great success with that happening. And then I also have the unique opportunity to train nationally with different law enforcement agencies and to speak with them very openly about their problems. And there is not typically that collaboration in many that I've spoken with university law enforcement and municipal law enforcement. And again, I think it goes back to a fundamental understanding of what this caseload requires to be successful, and the fact that there's just a general lack of education for law enforcement, be it campus or municipal in general.
I think there's another gulf besides the one between campus police and the area police, and that's between often student affairs professionals on campus, dean of students office, student conduct, other offices, departments, and campus safety. And sometimes that can be a huge gap, and when I go to my national conference, I hear that repeatedly. We just don't get along, we don't talk. I'm really blessed to work at an institution where we do talk, we do collaborate, that Safety Matters group, there are active participants from campus safety as well as our Springfield Police Department. I'd also note, and I don't think everyone can do this, but we've got a very unique situation that the Springfield Police Department has a substation on our campus, and they are responsible for the entire what our needs are as an entity and expressing appreciation for the important work that they do. Because I think often safety officers feel unappreciated, police officers feel misunderstood, and really sitting down and talking about what each of us brings that's of great value in helping students and helping citizens of our community to be safe.
I recognize another obstacle that we have, and I think I come from more of the traditional model where we have the university police, we have our city police, and then, of course, you have the organizations on campus that would be handling the investigations on Title IX Clery. And therein lies the problem. It's exactly that. We come at it from different perspectives with different goals, and sometimes we're crossing over and stepping on each other's feet, depending on timing of when the complaint might come forward. Say it's the end of the semester versus where it exactly happens. It can start off campus, come onto campus, and so forth. So we have that disconnect. We do try to collaborate. We try to communicate. We do not have a written policy. I think it's more unique to have a written, like, MOU or policy between the agencies. We're actually meeting next month for a joint working session towards that goal. But we certainly have different charges in mind as we come forward, and sometimes those are at odds. If I'm university legal counsel and I'm worried about timely warnings, that can be inconsistent with my city police investigation and some of the investigative efforts they'd like to do first before legal acts for campus containment.
So either one of the police officers or one of the prosecutors, if a victim reports to a campus police officer at either Cornell or Ohio State, and if that police officer then takes the statement, in your jurisdictions, does the detective then come after that and start over again? Or is the first statement that's taken from the victim, are you making an effort to have that statement be done by someone who understands the particular requirements of a forensic interview of a sexual assault victim?
So we have multi-jurisdictional issues, so we have cross-jurisdiction with not only local law enforcement but federal and state agencies as well. So our goal is always to first determine location, because that affects whether or not we have authorization to investigate from a sworn law enforcement perspective. But once we establish that, we don't even start an interview until we know we're taking them to the right place. And then we advocate as a law enforcement officer, not as a sexual assault survivor advocate, but as a law enforcement, someone who knows the system, to bring them to the right place and guide them to the right people to take the kind of forensic statement that you would want to have taken in those circumstances.
So your effort is to get them to the right place.
That's the
initially.
Yep. And then again, it's at their wishes. So if their wish is to let us know, simultaneously, we're letting our Title IX offices know that this incident happened. It doesn't matter where it happened. The Title IX is going to take that on and work their investigative process. So we sort of simultaneously launch both notifications, but we advocate with the student through the processes. It can be very confusing when you're working with a lot of different agencies.
It would be rare for a survivor to contact us immediately as the very first contact. Oftentimes it's either a hall advisor, someone in the wellness center, someone in student conduct, student life. Is that we assure that all of those support services are in place, are available, that survivor, as Chief Zoner said, is in the right place before we then really start to flesh out an interview schedule and touch base in terms of the kinds of interviews you're asking for or suggest.
These things are all done without an MOU in place. What we have found on a number of occasions is that our local law enforcement agencies aren't beholden to the DOE or any other directives to enter into any agreement. So if I approach them with something they're going to have to sign, they're going to run it up through their legal counsel, and they're going to either refuse to sign or not refuse to sign, but handshake and work with us. So we haven't had a problem working with people. The MOU doesn't drive whether or not we work with the people. It's never a bad idea to try to come up with something that forces agencies that have difficulty working together, but I'm not sure an MOU is the right thing for that.
We do have a Franklin County, excuse me, go ahead, Nancy.
Go ahead.
We do have a Franklin County sexual assault response protocol that's been developed among all law enforcement agencies, and again led by our county prosecutor, that serves as that roadmap or guide as well, a guiding document, and that's reviewed and analyzed and
the university is part of that.
Absolutely.
I just wanted to underline what Mike was saying about coordination being a bigger issue than just law enforcement and the university. It's an internal university issue, and there's also another key relationship outside of the university, and that's with whoever the community sexual violence advocates are, anti-sexual violence advocates are. And, SARTs have really been, sexual assault response teams have really been a key best practice that have been, that's been developed and shown to work over and over again, because you can pull in both the people internally that need to be coordinated and the people externally that need to be involved, and they all have to talk to each other. And my colleague from the Victim Rights Law Center, who does a lot of training with institutions, she was on the Title IX panel. She often says, you should start a sexual response team, but understand that for the first 6 months at least, they're just going to fight with each other. And that's sort of a necessary process because, as Mike was saying, there's sometimes there are a lot of dysfunctional relationships that need to be gotten through, but oftentimes once you get through those, you have a level of coordination and cooperation and sort of like-mindedness that you would never have been able to achieve without that process, having gone through that process. And I think it's important to understand that part of the reason why you want this many people at the table is because of the different goals issue. From a Title IX and a Clery Act perspective, the most important thing is getting the survivor, getting her Title IX and her Clery Act rights met, or his rights met, and those rights are based on equality in the Title IX context in particular, and therefore are much broader than anything that the criminal justice system can provide. The criminal justice system is really not about, it's about justice, but it's not about equality. And so it's important to set up a process, and that includes coordination, that can fulfill all of the goals that institutions need to fulfill, not just the goals of the criminal justice system.
I'd like to follow up on the point that you've just made, which I think is very, very important. In the course of the roundtables that I did around the state of Connecticut, I did 7 roundtables. We did a report, and we tried to address the issue of underreporting. Why are women, mostly women are victims, not coming forth more frequently? And this crime is hugely underreported, maybe outside the campus as well. Senator McCaskill and I have had some experience with the military system as well as the civilian. The underreporting seems to be a chronic and repeated problem, and that's one reason why enforcement is so important, because enforcement gives credibility. You can't have punishment unless you have reporting, and the effectiveness of punishment and prosecution in turn enhances the credibility of the system and leads to more reporting because it bolsters the trust that survivors have. Maybe you and I've heard Darcy and Alexandra, I've spent some time on the Yale campus, and others can comment on the issues of the different goals and to what extent more reporting can be encouraged by pursuing all of the goals, or whether some of them have to be chosen over others.
I think that it's important that even as we're talking about streamlining, that we do maintain all these different goals, precisely because survivors have such a range of needs, both in the immediate aftermath of violence and in the years that follow. So at Know Your 9, we've heard many different stories from survivors across the country. Some people at that moment really want public vindication through the courts. Some people just want an extension on their English paper. Some people don't want to have to see their rapist in their dorm the next day. And in order to, I think, really have a survivor-centered approach, we should really be embracing the fact that we have this wonderful opportunity to pursue different goals through different processes, depending on what the survivor wants.
And I would add to that that it's not just, I agree completely, that it's not just also offering as many options and available ways to report, but making sure that people know what those are and having clarity around it. And going back to what we were talking about with the MOUs, I think that one thing that will promote survivors coming forward is having that coordinated community response so that they see that the systems are working together, that there is collaboration, that they're not going to have to tell their story again. We've seen this model work in the Children Advocacy Center model. And so just being sensitive to the fact that, like Alexandra said, you know, it's not one size fits all in terms of what justice means. And I think for many survivors, just knowing that there are different outlets available that can make all the difference to them when they're ready to come forward.
I think it's just tricky. I think one of the big tensions here is making sure that different approaches are coordinated without being merged into one. So most of the survivors that we have spoken to out of hundreds said that they would be less likely to report to their school if they felt that that would necessitate some sort of police involvement. So I think that we have to be very clear that everyone is working together if they want them to work together, but that decision is ultimately up to them.
Although with my prosecutor hat on, I have to say that while I'm all for giving lots of different options, oftentimes you might negate my option of the criminal prosecution depending on how the initial investigation is led and how that's performed. It sometimes binds our hands, and we then have an inability to actually prosecute it when that may be promised up front. You can think about criminal later, but then it's run its course and interfered with our ability to do criminal later. So it's a fine balance.
I mean, it is such an issue, and I am really struggling with this. My staff is nervous right now. We go round and round. These cases are hard cases. They are makeable. And I know I have witnesses here. If the victim has the right kind of interview, the right kind of evidence, and the right kind of investigation is done as close in time as possible to the event. The more time that passes, the less likely there is that there would be a successful criminal prosecution, because a lot of this is about corroborating the victim. When you have a he said, she said, it is very difficult to get a jury to unanimously agree beyond a reasonable doubt, which was in my jurisdiction, if you don't have corroboration. Corroboration is sometimes very easy to obtain. And so part of this is my sense, and I don't know how we deal with this, and maybe Darcy, you can dive in here, is how do we have a system that is multi-jurisdictional in terms of people's roles and obligations, but that at its center is making sure that victim gets as much information as possible, as quickly as possible, and fully understands that waiting to think about whether or not her brutal rapist will ever have a difficult interview with somebody in a uniform, or whether her brutal rapist will ever have a fear of actually going to prison, has everything to do with her willingness to not only come forward, but come forward quickly. Right. And I don't think that, I mean, what my sense is after all these roundtables is there is almost a bias in the system away from the criminal justice system. And I understand why the criminal justice system does not have, we've had some, I'm speaking writ large, not me, or hopefully the professionals I worked with when I was doing these cases, but there's some horrible stories about how victims have been treated and the way they've been talked to and the way that their cases have been handled, and that is being used, I think, almost as a cudgel to, in some ways, keep victims from believing that there are people like the people on this panel that will listen and investigate and handle their cases in a very professional and supportive manner, obviously with an eye towards the facts, not an eye towards a certain result. But how do we do this? I mean, how do we, help me here, prosecutors and detective, and help me here, advocates that are worried about victims not having control. Maybe, Carrie, this is where you can talk about you have options.
Yeah, and if I may, I'm dying to answer everything that you say. So, and anybody who knows me here knows. So a lot of what I think you have been hearing, and I am notoriously hard on my own profession, so I'm going to acknowledge that first. But it's because we do not have a great history of doing this caseload, sexual assault, well. And I'm not saying that that's everybody, but let's just address the fact we don't. If we were doing these well, we wouldn't be sitting at this table. Okay, so I always have a problem with legislating or with putting rules forward for law enforcement with the assumption that they're going to screw it up, because I don't think that solves the problem. And there is a really wonderful trend now, thankfully, among law enforcement where they're starting to acknowledge that this has to be done differently. And the traditional model of policing that works for all these other cases doesn't work in sexual assault because the dynamics are so drastically different. So for instance, when we built this program, this was back in 2009, before any of these conversations were happening. We never intended to be sitting here today. All we wanted to do was make things better in the city of Ashland. But what we did is we went to every victim that was willing to come forward and report to us, and we asked them, if you could change things, what would you do? No restrictions, whatever it was. And I completely agree with you, because every person answered that differently as to what their individual barrier was. So anything that goes forward that's coming from someone assuming what a survivor wants is grossly mistaken. You cannot do that, because what is right for one survivor is not right for another. And for anybody in a profession to assume that they know what the answer to that is egotistical, and it is damaging to this caseload. So what we had to do as law enforcement is we had to get out of our own way. We had to say, tell us how to do this better, because obviously we're not doing it well. My chief, who is extremely forward-thinking, says it best. He says, listen, let's just take the highest statistic of 34%. Right? If we say, and I don't think there's 34% of reporting, but let's just say there was. Even if we were 100% successful in all of those cases, it's still an epic failure. So we had to do something different. And what we said was, let's try everything they asked us to do. And the one thing they asked every single time was for confidentiality. Now,
you know, that is such an important point. And at the end of these roundtables that I held, I came up with a Bill of Rights. For survivors. And one of the rights was to confidentiality.
Yes.
And I think this discussion is extremely valuable, but the other thing we did in the roundtable was we heard from survivors about how this system looks from their perspective. And what impressed me at Connecticut College and some of the other places, and maybe we can hear from Jessica as well on this issue, is how they provided advice to the survivors, because that makes all the difference as to whether, number one, somebody comes forward, and number two, whether they stay with it. Because it's not only the initial report, it's also, where do I go from here? You know, am I just going to retreat? Am I going to take the semester off because I don't want to run into this guy? So I think the initial, maybe we can hear a little bit more about how, you know, you have options, you have choices, confidentiality, how all of this looks from the standpoint of the survivor.
Right. Well, there's actually research that says if you have an advocate from the very beginning, a confidential advocate, that you're going to be more likely to be continuing through whatever administrative or criminal process. So if they have that advocate, they're going to be more likely to cooperate. But I think what has to happen is there has to be trust, because advocates some of us really do promise that we don't have an agenda. We're not telling them to not report, which I fear is sometimes the problem, is they're thinking the confidential advocates are turning them away from some of these options. So what I can promise is that I will give them all of their options and let them choose, because they do come from a victim empowerment model, and then support them whatever option they want. But I think there has to be that trust that we're not turning them away from one of those options, but fairly telling them what they are.
Darcy?
And like Jessica, I mean, we're totally giving many options, but the big piece, too, is that I want to be open and honest with students, that it's not like an episode of SVU and it's not going to be over in 45 minutes. And I think that with our population, you know, it may happen their senior year and they're off to a job 4 states away. And so that's a big inhibitor, that students might not necessarily come forward for the criminal justice system because that process could take years to go through. And they just want to move on with their life and do something different. Where with the Title IX model, 60 days, something has to be handled. And to your point, Senator McCaskill, about having somebody come in quickly, it may take several days, several months for somebody to decide to come and see an advocate. And at that point, even if they turn around and say the next day that they want to file criminal justice or, you know, criminal report, then that time has passed.
Right.
Where again, at least at Connecticut College, we don't have a statute of limitations. So if something happens as a freshman, a student can come back senior year and file that report. Obviously, the case is harder to prove, but that option is still there for a student. And I think that that's important, too, to remember, is the length of the process.
I'm sorry. I was just going to add, not only the length, but it's the different types of evidence. We're in the criminal justice system. It's beyond a reasonable doubt. And then we've got our administrative process, which is a preponderance of the evidence, more likelihood than not. Right. You're going to have victims wanting to go with what they might see as the easier, less burdensome.
And the people that are on college judicial panels have all been trained as federal mandate, where an average juror is making a decision. So your prosecution, your police officers could be doing an amazing job with the investigation, but if that defense attorney does a really great job...
They haven't all been trained,
right?
Just so you know.
Yeah.
The adjudication panels on college campuses haven't all been trained.
Well, that's
they probably have been at Connecticut College, but I can assure you they have not been across this country.
Right.
We have a variety of people making these decisions that are asking wildly inappropriate questions at these adjudications.
Right.
We use the Survivor Bill of Rights, Mr. Blumenthal, and offer that on our campus. But what time frequently we see that where that runs headlong is to public records laws and restrictions that require us to make our police records open to a very large extent, even with listing survivors or victims' names, releasing those to the public. So there's a... While that may be a best practice, I think that's going to be a challenge for some states to do that.
Well, how do you all handle public record stuff in terms of your model and where the victim gets to decide? Because this is very similar to the military system, restricted and unrestricted reports. So what happens on public record requests to your police agency on a report where a report's been made, but she was wanting to keep it confidential?
Sure. And let me say first, too, that the difference between us and the military model is that we're getting the information to those that are actually doing the investigation. And so that's the goal from the beginning, where it's not going to somebody who is restricted and not doing the investigation. And that's what I do believe. I believe this information needs to go to law enforcement, but with the victim's permission. So specifically to when these reports are released, what we do is, and again, this is a huge break from traditional policing, but we can do this legally, and it may vary different state by state. In Oregon, with public records laws, again, that is when a case has been closed and is no longer being investigated. So we have pretty lengthy statutes of limitations. So what we do is we inactivate it. It doesn't mean that they've told us they never want to do something. They just don't want to right now. And it really solves a lot of problems, because how in the world can you expect a survivor to make a determination about adjudication when something has just happened? I mean, there's no way. Frankly, they wouldn't even have the information necessary to say whether they want to prosecute or not, because we don't have any time corroborating that information. I mean, we don't even know if they have a triable case. So that's never even a conversation that we have. We document everything they'll let us. And what it does is it does help with some of those delays that you're talking about. What I would also say, though, is we can overcome those delays. That's a very traditional policing response, to say, oh, it's a delayed report and therefore it's, you know, unlikely to go forward.
Right.
We actually have shown for years now that's not the case.
Right.
We give much better cases because we're working with a victim the entire time. It's not adversarial. It's not, you know, I need you to do this and you don't have a choice in it. prosecutors get much better cases. Now, what I would say is when that case is inactivated, we don't have to release it. Of course, could there be a time? Yes. But again, you'd have to have somebody that knows they made the report to come request the report. And I think that's pretty unlikely. It's not impossible, but it's unlikely. Now, when we get to a public records typically is we've already come to a decision with that victim that they want to go forward with what's called a complete investigation. That is a traditional model. It goes to the DA's office, and again, the options are not available at the DA's office because we're not going to tell them how to do their work, but the victim understands that before we make the decision for that to go forward.
So if it goes to the DA's office and the DA's office decides to nolly it and not take it, then it becomes open?
Yes.
But the decision is by the victim as to whether or not they want it to be a complete investigation with the possibility of referral to the prosecutor.
Yes, absolutely. It's completely with them. We want to keep it inactive and not close it for as long as possible because we have found time and time again.
You're going to do it again.
Yeah, the way they feel at 6 months, and maybe if we, and again, the other half of the program is we identify serial perpetration, which changes the entire conversation, right? But let's say we don't. We could still get someone coming in 2 years later that says, I'm ready now. And because we did a good job documenting it, we did a good forensic interview, we audio recorded it, our prosecutor stands a chance. And I'm not saying it's easy, but it's better than it is.
Jennifer, were you going to make a comment?
Oh, going back to the students and, knowing their options, the sense we get is that they're given an option. You can go to law enforcement, but then it's with the negatives, and there are negatives to law enforcement. Obviously, our standard of proof is higher, and it does take more than the 6 months of your semester to finish a case. But I don't know that when students are given their options, they're also told sort of the positives of law enforcement, which are that the law enforcement officers will be able to collect more evidence more quickly, especially in cases where something happened off campus. They have more power there. And that if you ultimately have a result in the criminal justice system, it's a permanent result. The person will have a record, your orders of protection, you will have an order of protection that will last many years. We had a young woman who was sexually assaulted on campus outside of New York State, had an order of protection on campus, came to New York for a job, and then the offender was coming to her workplace, not doing anything criminal, just violating that order of protection. And it was completely unenforceable. So I think they need to be told their options, but maybe in a written form that says, yes, this is your law enforcement option, and it will take this amount of time, and this is the standard of proof, but these are also the benefits of it to encourage more reporting.
Yeah. Alexandra, do you think that, I'm sorry, do you think that it is fair to say that now victims are being discouraged from reporting to law enforcement overall? Or Nancy or Darcy or Jessica, do you believe that victims are being told all of the negative about going to law enforcement and not being talked to about the positives that could come from going through that system?
Yes. So I can say when I reported violence to my school 5-6 years ago now, I was explicitly told not to go to the police, that it wouldn't be worth it, that it would be emotionally draining. With that being said, I know I never would have come forward if I had been forced into that option.
Right.
So, and we've also seen another version of this where most schools offer an informal or formal complaint. So you can go through a disciplinary proceeding where the assailant might be suspended, expelled, if your school is doing a good job, or asked to write a book report, or an informal sort of mediation response. And we do see schools doing sort of a similar thing where they say, you have these two options. You can go informal or formal. But if you go formal, it's going to be really hard and you're going to get behind on your schoolwork, just letting you know. And I think that some of that comes from the position of these administrators who might only talk to that student while they're actively engaged with the board. So they see a student who is, these are hard proceedings, who are really drained by it for those months. What they don't see is the student who is forced to spend time with his or her rapist for 3.5 years on a campus because he or she went through mediation rather than a disciplinary hearing. So I think that this is definitely an opportunity to talk about, sort of in the along the model of a Bill of Rights, what's the kind of language that schools should be using to present options that's drawn from the experiences of people who have gone through this process, that have implemented this process in many different ways.
Well, Sorry, I think that that comes back to the importance of MOUs, and even if it's not a formal written document, just the relationship building, because I was on a first name basis with our detective and can call him from my cell phone, you know, so having that reassurance where when a student does come, I can say, we can call this person, and give them those positive aspects of things. And I think back to Jessica's point, how important it is to have an advocate through the whole process, because yes, it may be hard, but I will help all along the way. Do you need help with your academic stuff? Let me talk to your dean. You know, so being real with a student, but helping them through all of that is so important.
And one of the rights that I incorporated was to an advocate, confidentiality and advocate. You know, they're different terms. And by the way, Senator McCaskill and I joined in expanding the right to an advocate within the military system. So I thought, from what I heard in my roundtables, that the idea of an advocate who would provide advice. It's not just that the advocate speaks to the world in advocacy, but also can advise on these options with confidentiality, because that's what an advocate, a lawyer, does for a client. Rather than the university having that obligation to provide advice, which really puts the university in a very anomalous and conflicting position, the guarantee of an advocate provides those rights.
I'd like to speak a little towards the confidentiality piece as well. And in that, you can have the best forensic interview, you can have the best prosecutor, you can have the best case going forward. You can maintain confidentiality throughout all of this. And social media just ends around and gets you. Enough information is generally present because we're not usually the first people reported to, even as an administrator, a friend, or a friend tells another friend. So the battle that we have, or the blame, I think, that our system takes on for lack of confidentiality is sometimes actually, it's just the leakage of what we have to deal with right now. And there's very little we can do to manage that. It's unfortunate, and it's also very impactful on the victims. It's very impactful on the investigations. That people are presuming things that have happened. They tell stories. Once a comment's out there, it's unretractable. And these are battles that we all face.
Another challenge.
99% of which would not be admissible in court. So.
But it does impact the ability to move forward, and it impacts
the victim.
The victim tremendously.
Yeah. And control others from coming forward.
Exactly.
It's even fundamentally on posting the report on the daily log that we're required to keep. Unlike municipal agencies, every incident report goes on a daily log. It's reported at the classification of the offense that we've classified it, you know, a rape, sexual assault, whatever it might be. You know, another challenge that will have to be resolved in this issue as you wrestle with the issue of confidentiality. Interesting.
And that log is under Clary, Chief?
Correct.
Yes, ma'am. Interesting that Chief Zoner and I were talking as well. We've used social media and technology to assist building cases, and I think the prosecutors might be able to speak to this more, but everything from video evidence, you know, as we enhance our camera systems on campus to observe and confirm that people were coming or going. We do subpoena phone records, we subpoena email, text messages, and help build that case. So at the point that the case is ready for court and the survivor says, now I am ready, we have that case built, and a lot of confirmation information that's built up through a really aggressive evidence collection process.
Only if law enforcement is allowed to be involved in the process to begin with, because if they're not given that option, we lose text messages too quickly, we lose content, we lose all of those things. So we have that inability, if there's not truly a real option to go law enforcement after you've, you know, it's that basic needs discussion, which is, I just need the person away from me on campus right now. I got to make the decision about criminal later, but we lose what we lose.
Yeah, and how common is it that this report comes to an RA or comes to someone who is not part of campus police and stays within the administrative part of the university? It's kind of to your point earlier, Nancy, that it never gets to even campus law enforcement for the kind of subpoenaing of phone records or text messages or things of that nature.
Well, if that's the victim's choice, if that's the survivor's choice, then that, you know, there's nothing wrong with that. right, if it stays within the institution. You know, if, for instance, she has no interest, or she has no interest at that moment in pursuing a criminal investigation. But, you know, the dilemma for the on-campus person who is advising a survivor, you know, in the moment, in the aftermath, the immediate aftermath, is, with regard to the criminal process, is that you have to balance between giving full informed consent, or you know, giving enough information about the options so that she can make an informed choice about the options, and you're restricted in terms of what information you can give her by what the options actually are, right? So we're not all living in Ashland, Oregon, unfortunately, and not everyone has a criminal justice system that is structured to give multiple options and to hold on to evidence for years so that there can be a prosecution later if the survivor is ready for it. You know, all of those things are relatively uncommon, and if you are going to be a good advocate and support for the survivor who's come to you as the campus person, then you need to give them an honest idea of what they can expect from various processes, you know, whether it be internal or external. And, you know, some of those are just going to be fact-based. And I am going to be very clear with anyone who I talk to that, you know, if you have this goal, if your goal is to not have to see him in the cafeteria, then, you know, you're going to be better off going through the university's Title IX system. If your goal is to have him incarcerated, then we need to talk to the police.
Or what about a goal of him not doing this to another woman? Mm-hmm. Is that ever presented to the victim?
We want to empower them, because I wouldn't say that to a victim. You should report, because I don't want this person to do it again, because I'm focused on them and what their needs are as a survivor, and I want them to feel empowered to choose what's best for them. And they shouldn't, and while I want this person not to rape anyone else, that shouldn't be on this victim's burden. They've already been victimized. They've already lost power and control. Why is it their burden now to have to do something they don't want to do? So I struggle with that, because I want the bad people off the streets, but I also want to empower someone to do something after already losing power.
I think that there's also just a practical concern. I don't think this is, do we have students report to their schools, or do we hold perpetrators accountable, for a couple of reasons. One, because schools can hold perpetrators accountable, because often the criminal justice system does not hold perpetrators accountable. And because ultimately, if we don't, I understand that if we don't push survivors into the criminal justice system early, we might miss out on text messages. But if we do push them in, we will miss out on survivors.
And let me, I'm going to say this from a law enforcement perspective, and it's probably not one that you would hear from many law enforcement officers, unfortunately. But what we have learned, and it took us a while to get there, I mean, there was years of fleshing this out, and it still makes us uncomfortable. We're not happy with it, because, of course, we want to get to a place where we can arrest serial sexual offenders, because that's what they most are. What we had to realize, again, was in order to get there, we needed to understand and fully acknowledge that it is never the victim's responsibility for that arrest. They are never responsible for the offender doing that next offense. The offender is responsible for that next offense, not the victim.
Correct.
And we cannot lose sight of that, because what we hear, and I hear this in all different groups, all different professions, not just law enforcement, I hear it in advocacy too. We will get to a place where it makes us uncomfortable, right, to acknowledge that somebody could know that this happened and we're not doing anything about it. What I think we have to realize is we are doing something about it by allowing a survivor to enter the criminal justice system in the way that's right for them. And so the focus should not be, she didn't come forward and give us everything. The focus should be, we're grateful that she came forward and gave us anything. And that's a very different perspective that changes the entire caseload. You will be successful if you come from that perspective.
So is your reporting up?
Yes, 106%.
Over what period of time?
From 2009 was our 0 year where we did nothing of this. 2010 to 2013 was a 106% increase.
And to what extent can any of you comment? Do any of you have numbers like that, either up or down, based on changes in practices?
I can't cite the exact numbers. I do know that we've been in discussion in the groups that we have seen an increase in reporting. As a matter of fact, we've been under fire for increased reporting. This is actually what we're trying to see for at least, as you said, from a year 0 forward. We actually hope to see.
Who is giving you trouble about increased reporting? Because I'll
parents,
call them.
other students.
Yeah, they should understand. The campuses that say that they don't have a problem because there's none that are reported are lying.
Right.
When
Or
people
they have
ask
the biggest
me,
problem.
Or they have the biggest problem.
They're lying and denying.
right,
Lying or denying or incompetent.
right.
Or setting up their processes so that it chills reporting.
Right.
Right?
Which raises...
Which is not always, to be fair, it's not always a sort of, it's not like there's some evil mastermind who's, back in a back room setting things up to chill reporting with the goal of chilling reporting. I think that it happens in a much more subtle fashion, and one of the ways in which it happens is by importing unnecessarily criminal justice-y like processes in the traditional policing model, importing those processes into administrative processes that don't have the power even to do the kind of coercive things that the traditional model sort of relies upon, right? So schools don't even have the power to subpoena witnesses, for instance. And so, they don't have the power to collect forensic evidence. There's all kinds of things that they simply cannot do.
Right.
But yet they are importing things like, right to counsel, or they're having evidence collected that would be forensic evidence, but some campus police officer is just keeping all this evidence in their office. And all of these things just mean that it leads us to believe that the campus system is the same as the criminal system, and the criminal system doesn't have a good reputation when it comes to sexual violence. So that ends up chilling reporting just, by operation of a bunch of, as I said, pretty much unintentional things, but it ends up being quite effective. The lack of reporting can be seen as a veto on the system. If you have fewer reports, that means that your system is not doing what
I think the point I was trying to make is this: if you have a lot fewer reports at any given campus, no parent should take that as a signal that there's a lot less sexual assault.
Right, which is why, the mandatory survey idea is, the way to kind of level the playing field between the various, all of the schools, because they'll all be collecting data on the same basis and separating data collection from getting victim services, which, as Jessica said, is what reporting should be about, is helping them to access what they need, rather than depending on them to solve our crime problems for us.
I think this is a very cyclical problem, though, and it's what we keep talking about, is what their goal is on day 1 could be very different day 10 and 6 months down the road. And it shouldn't be just an us versus them, us being criminal versus administrative process, because what I find is that after, there is a discouragement. You asked the question, are people discouraged from going to the criminal justice system? You can see there's already a built-in perception that you're not going to get justice or be treated properly through the criminal justice system unless you're doing it right. And I think we're doing it right where I'm at. But the point is where I find our difficulties is if they're not truly vetted then they come to us after it was a 5-page paper. That was the sanction. And then now they want us to do something about it. And at that point, we're so hampered that then they say, see, you never take cases anyways. And it's just a perpetuation of the reputation that we're not helping them and that we're not there for them from the beginning. So if there's an Ashland approach where we can collect, I can sit all day long, I can wait a year, 2 years, whatever, until the survivor's ready to move forward and move through the system. Just help me get some of that evidence at the get-go, from the beginning.
So you're saying they're coming to you after they're dissatisfied with the weak result of the administrative process?
Yes.
And if there, that's the whole reason, right? This is just the right thing to do, human element of this program, but we're still criminal justice. And so, we say this gives options to survivors, but it also gives information to law enforcement. That it had to be beneficial for both. That's what we discovered. So traditional law enforcement is only beneficial for law enforcement. We go forward in the way that's best for us. And I'm obviously overgeneralizing here, but that is true. It needed to be beneficial for both survivors and law enforcement to be effective. And what I could say is, I hear the try here to get something from the administrative process that can be helpful for the criminal justice process. And if I could say, the one thing I have seen throughout the years that would make the biggest difference is to have some mandate that anybody who is interviewing a survivor of sexual assault be trained to do so, and for that option to be recorded. So the victim has the option to demand that that is recorded, because I can't tell you how many reports I've been given where somebody did a synopsis of what a survivor said, and it was nothing of what the survivor intended. Right. So if those two things happened, I can take that case and I can corroborate it 5 years later. But I have to have that audio recording of what was actually said by the survivor, by who interviewed them. And those two things could actually make a difference.
And that's your interplay with the 60-day on Title IX, too, because it depends on who that lead investigator is, what and how they're trained, and so where their pushes and timeframes are, and where that steps on the toes of the criminal justice system for our ability to just wait and pause for a while.
So does that work better with the single investigator model?
I would think so.
I don't know about that. I'd be curious what the advocates and the survivors think about the recording, because I've been in conversations that say that is chilling in itself, that by recording it does put an extra burden, that their testimony is going to be impeached at some future point, or particularly if their recollections change, or if they come out of trauma and they have a whole different perspective on. I'd just be curious.
But if the interview's done right, then their recollections aren't going to change, because the interview will not ask them to remember things they don't remember, but will rather just ask them to say what they can remember, as opposed to a typical, as you well know, Chief, there's two different kinds of investigative interviews, and this kind of investigative interview is acknowledging they may not remember everything. And we don't want you to remember things that you don't really remember, because what happens so often is the victim will try to bootstrap their credibility by making up things they don't really remember, because they're so worried whether or not they're going to be believed. And that's the exact opposite of what you really want the victim to do.
And again, if I can address that, we had all these same in the beginning, right? We had all these same ideas, but what we did is we went out and talked to researchers, we consulted with victims, we consulted with victim advocates heavily. They're who built the program. So what we learned was you had victims who traditionally didn't want the recording if it wasn't an option for them. But when you sit down and you tell someone, I'm not going to make you do this, but here's why I want to, because I want to accurately reflect your statements. I don't want to sit down 2 hours later, if I'm lucky, maybe it's 2 days later that I sit down and write my report, and guess as to what you said. And I want to, if you disagree with what my report said, to be able to go back to this and make sure that I'm right. And I also never want someone later to say that you said something you didn't. And I have never, ever in 4 years had someone tell me no. Ever.
But when you gave them the option.
But it's never been pushed on them. I explain why I want to. So, and we have had people say, I'm not ready to do that yet, right? Like, I need some time before that happens. And again, I'm a forensic interviewer. We do this for kids all the time. This has been a model that has been replicated well for children. And I'm not trying to say that adult survivors of sexual assault should be treated like children. However, they should be given the opportunity to talk about what they're able to remember in an environment that is accepting and understanding of trauma. And we do not do a good job of that with law enforcement.
And I think that gets to the bottom line of I wish that we all lived in Ashland, Oregon sometimes now. I'm moving. But I think that it gets back to training in trauma-informed interviews and in forensic interviews.
And I think that's a very important point because it gets us back to what we can do. You know, what we, meaning the Congress, the legislature, as much as I miss my prosecuting days, we're not going to be, neither of us is going to be doing that. And I think supporting training is so critical, but also are there models for how the administrative, the school deals with it that would be useful? Because, and I want to sort of address a point that you made, Nancy. You know, I think there are due process requirements for the schools as well, because they have the power to have an impact on individual lives that it can be transformative, that can change those lives forever. So they have a responsibility, you know, it's a due process responsibility, it's a fairness, it's a justice responsibility that I think is as important as the criminal justice system. The standards, the procedures may be different, the obligations may be different, but they need to be concerned about those obligations as well. And it goes back to, you know, maybe the victim needs an advocate there too, with the administrative process. It may not be you know, we don't want lawyers sort of dealing with this as a mini trial necessarily, but are there ways that we, the federal government, can help with that administrative process? Number one, training. As Senator McCaskill has said, we've, you know, heard about training and the lack of it, and the diversity in how universities approach these issues, but are there sort of models that we could encourage?
Well, one thing that I think sort of gets lost is that, in fact, universities can very easily meet their due process requirements, their administrative due process requirements, at the same time that they meet their Title IX requirements, because actually both of those legal regimes require equality of procedural rights. So if you just give equality to both sides of the proceeding, then you're going to be meeting both of those obligations. The administrative due process obligations, as set out by the Supreme Court and enforced by many, many courts, is many lower courts, is, you know, notice and a right to be heard. And that's just for state institutions. Private institutions proceed under contract law, and all they have to do is follow their own procedures. Now, everyone has to follow their own procedures, as, you know, the state schools have to follow their own procedures as well, but they have these constitutional requirements as well because they're state actors. But even in the case of a state institution, the requirements are really quite minimal in comparison to the criminal justice system. And that's critical because it makes it possible for schools to put the complaining student and the responding student on an even playing field. The criminal justice system doesn't do that, and there are reasons, there are good reasons for why that is, because the criminal justice system can throw someone into jail or put them to death, and that those kinds of issues are not relevant in the campus context. So for the campus context, what they need to be doing is protecting the living and learning environment of all of their students, which means equality, and is also what Title IX requires. So all of these things, actually, you can have a very robust administrative process while meeting the legal requirements on all sides. And there's a tendency to assume that the criminal justice due process requirements are the same due process requirements for all proceedings, but that just isn't true, and that's not true based on Supreme Court precedent, as well as many, many lower court judgments in these cases.
I totally agree, Nancy. And at our university, and I don't think we're unique, but we have, following Office of Civil Rights and what they've provided as guidelines, a number of us, not only our Title IX coordinator's office, but also in student conduct, we've gone through Title IX investigator training and have made the shift in our conduct process when we're dealing with issues of sexual violence. So we're not using the traditional model, which is more adversarial. We try to be fair, but now that I've been introduced to the investigator training, I see a huge difference. And this is just, the student conduct officer reporting that adopting the Title IX model and following through very well with it, we are getting more education and more cooperation from the respondent. They used to lawyer up immediately. First thing, you're cut off from talking to your student, which drives me crazy, by an attorney saying, this is my client, and you don't talk to him or her directly, you talk to me. The Title IX investigation kind of just melts all of that away so that you proceed in a very objective, fact-finding manner, and everyone seems to get more on board with it because they know you don't have a particular outcome that you're searching for. The outcome will rise from the facts.
Do you think they would, do any of the schools that you work with or that you're familiar with, are any of them using students on their decision-making boards?
Yale is, and I think it's a bad idea. I think that students are discouraged by the idea that now not only might they have to see their assailant in the cafeteria, but they might have to see the person who they told their story to.
Do we have any idea, there's probably no one here that would know that, maybe, Nancy, how many schools are still using students to make these decisions?
No, I don't know that.
That's something we need to find out. And maybe we need to even think about.
I would say that, just because it's sort of tangentially related to this, that, one of the problems in this area, and I say this as a researcher, is just there is too little research on what is actually going on.
Right.
And that is connected to the transparency issue in a couple of different ways. One is that if schools have an incentive to pretend that this is not a problem, and they're successful in pretending that this is not a problem, then the last thing they're going to want to do is empower their faculty or anyone else to be conducting research as to the extent of the problem and therefore how to fix it, right? You need research on the extent of the problem before you can determine whether or not you can fix it and how to fix it and whether the ways that you're seeking to fix it are actually effective. So, I don't know the answers to that question, in part because there is an enormous research gap, and part of the reason why there's an enormous research gap is because of the transparency issues.
And while I don't know who's using students or not, but my school did away with hearing boards long time ago and just use the investigator model. And being a victim advocate, I can say that we have a lot more victims wanting to go through the administrative process when they're told they're just talking to a trained investigator. It's the only person they have to talk to. They don't have to face their faculty, their students, their suspect. And so I think that is a more victim-friendly model. And so I do think we need training, though, on not only the investigators, the administrative process, but the police. Anyone who is talking to a survivor could be something that we could have more of.
And that may well include, you know, the dormitory, I don't know quite what the terminology is on all of your campuses, but the person who's in charge of the entryway, the student advisor, who often may be the line of first reporting. In other words, you know, at midnight when a distraught student wants to talk to someone, if it isn't the roommate, it may be the person who, and maybe a grad. Yeah, exactly.
Right. And I think that's where other training could be, because the first person that someone's going to tell after a sexual assault is going to be their friend or the resident hall advisor, and how that person responds is going to influence if they actually want to report it to anyone or tell anyone again. So if the first person they tell believes them, supports them, and knows the resources, that person's going to be more likely to go through the process. So we also need to be training our community.
And they're going to be more likely to go to that first responder if they understand that what happened to them is a crime. So I think we need to get some very baseline knowledge out there, and I know this has been talked about at other roundtables, but just so that people, you know, all of this conversation is assuming that people get to a certain stage in the process, and I know that so many survivors say, what happened to me wasn't rape.
It's interesting because it is so fascinating to me that in this day and age there are so many young people that think rape can only occur between strangers. They don't think if it's rape between people who know each other that that is the same thing. And you're right, there is a baseline. And talk a little bit about some of the statutory challenges we have in states. I know that New York has a, and it's, you know, I think every state is different about incapacitation and consent. Let's talk about that. And that's not something we can fix, obviously, in Washington. But I think it's important that we acknowledge that there is work to be done at the state level in terms of underlying statutes.
Well, there's certainly a gap between the college definitions and the college policies on what is sexual assault, and then our state statutes, what we can actually prosecute. That goes back to what you said before about sometimes people do go to law enforcement and they're sent away. There, in New York State, obviously a forcible rape is a rape. If someone is intoxicated to the point of being physically helpless, so they're sleeping or they're unconscious, that's a rape, that's a sexual assault. But if a person is voluntarily intoxicated but still functioning, walking, talking, and participates in the sexual act, they're not presumed to be unable to consent. It's not like driving while intoxicated. You know, you're .08 and you're presumed you can't drive. It's not the same. If you're intoxicated and you did that on your own, you're still considered legally able to consent. So that's sort of a difference between our state law and what a lot of the policies that we have in the colleges that we have in our jurisdiction say, where a person is, you know, not consenting if they are intoxicated to the point where they're not making a rational decision.
That makes me thankful to be a prosecutor in Colorado, and it goes back to your initial comments and questions about what does consent mean. Like you're talking about the definition of consent and the overplay with intoxication. In Colorado, we do have the physically helpless standard, but we also have an additional standard of incapable of appraising the nature of your conduct, which is going to encompass the bulk of what we see, which is the intoxicated, you know,
voluntarily intoxicated,
yes, voluntarily
on the point of being able to,
but not all the way at the passed out stage. So we're in that gray area, and you need that kind of state protection in order to, you know, an alternative. We often, of course, alternatively charge those or look at those as two different theories of prosecution. But certainly, I have greater options before me, and so that's a very, you know, important note.
What about rape shield statutes? Do we need to legislate rape shield statutes for the university-based administrative process? We have them in the criminal justice system. That is, that it would be irrelevant and not appropriate to bring into the adjudication process any evidence that would have anything to do with the victim's prior sexual conduct?
I would hope that every university in the country would be committed without any legislation.
No, we've talked to victims who've been asked.
I'm sorry, but
yeah. We've talked to victims who've been asked questions that would be highly objectionable in a criminal courtroom.
And that's really, you know, what occurred to me when Nancy was talking about, well, all we need is equality. You know, what occurred to me was, well, if, you know, you have equality, we've heard about, or at least I have, situations where the accused could literally interrogate the survivor. Mm-hmm. Well, giving the survivor the right to interrogate the accused may not really be equality, especially when it comes to certain areas like past experience. So Senator McCaskill said maybe there need to be some kind of limits.
Right. I mean, I think that's about, when I say equality, I mean equality of rights, procedural rights. So you can set up your proceedings so that no one cross-examines anyone else, right? And a lot of schools, even that continue to use the hearing board kind of model, have adopted a system whereby neither of the two students are allowed to talk to each other. They have to give their questions through the board. So that's an improvement. It's mainly just, and I think that this, getting back to Becca's point about this, making sure that students understand that what has happened to them is a crime. I also want them to know that what happened to them is a violation of their Title IX rights. It's a violation of their right to equal educational opportunity, and that's, that gets, they don't understand that even more so than they don't understand the fact that it's a crime. Alexandra, I'm sorry, I interrupted you.
Oh, no, I was just going to say that I know a student who lost her disciplinary hearing because she had a previous sexual relationship with the offender, and the board decided that based on that previous relationship, it was okay for him to take cues from her body language, that even though she was saying no, she really wanted it, which was literally the school saying no means yes.
You asked the question earlier, and I don't pretend to be an expert on the administrative process by any means, but what I hear from the prosecution side where we still have some problems, especially so the high focus, and if a school is underpinning a complaint, there's this enhanced reaction and almost feeling that I need to make sure that I'm being so appropriately consistent with Title IX that you can get an overreactionary response, and we can get crosswise with our local law enforcement. So, for example, a timely warning requirement. If a survivor is not ready to move forward yet, but they're struggling with, like legal is struggling with, well, is there a serious or ongoing threat? I don't know if there's an ongoing threat because they're not telling me everything. So in the exercise of caution, because I don't want to get crosswise with Cleary, I'm going to do a timely warning, which can blow us from the beginning. It outs the survivor oftentimes, and it blows the investigation from the beginning. So over-legislation is almost sometimes...
Yeah, I don't know about this timely warning thing.
And so that's a problem.
We've actually
do we need the timely warning in sexual assault cases?
We've actually had some success in circumstances where you're dealing with more likely than not a consent issue, especially as it involves maybe intoxication or drug usage. The incident isn't what you're telling people about. What you're telling about is how the incident came about, and it's a very fine line. And we've been able to work with language that we have to be very careful. We don't want to be in a position where we're using language that can come across as blaming the victim for being in a circumstance, and yet the circumstance did add to the situation and the confusion. So using language very carefully to say that there was, in fact, a report of a sexual assault, so we're being transparent, and we do say something happened on this campus, and then just sort of trailing out a little bit, because sometimes the report doesn't come to us in arrays. It still might be an ongoing threat because we might be dealing with the background of the serial rapist. Right. So you need to get something out there, but you don't have enough information to move anything forward other than to say, this is still a pervasive problem on campus. It's not gone away. Your timely warning is actually a re-advisory that the world hasn't changed enough that we can move forward from here.
I also think there needs to be some reality about how this crime is perpetrated. A timely warning, what exactly is that going to do? Because to me, and again, I'm not an expert at all on the college process, but I'm just thinking from a common sense standpoint and somebody that looks at these cases and investigates them, this is reinforcing the myth that people are jumping out of bushes and sexually assaulting people. That is not what's happening. So if it's non-stranger sexual assault predominantly, any warning that goes out, so everybody is going to think, well, that's not going to happen to me anyway, right? I mean, because it's always a surprise attack because you're never thinking the person that's going to do this to you would do it to you. Right. Therein lies one of the fundamental, what makes it hard to investigate these. So that timely warning just seems so counterproductive and also just reinforcing what we are all trying so hard to fight to get out to society, that is not the reality of these cases.
I can live with what Chief Zoner and Detective Hall just said, but when you're facing a potential Clery audit, the Department of Ed, you are probably going to
we need to look at this.
Think about this differently. And again, if we're identifying challenges here, that one should be very upfront and foremost. Because the other
we are capable of over-legislating.
The other extreme that we've been
We have done this on several occasions, I might add.
Well, and we've been on the side of before timely warnings, and it's been spoken of today about hiding the reality of sexual assaults on campus. And I think they should never be so specific that they would out the victim. They should never be that specific, but it does say...
If your campus is small enough, you can do everything you can.
See, I mean, if you're dealing with a small campus and you say it occurred, then you're asking for social media, you're asking for all of that.
Right.
I think we've got to really look at this. It's one thing if it is a jumping out of the bushes, a darkened part of campus where someone has been physically assaulted and sexually assaulted by a stranger, but it's a whole other thing if it's a drunken fraternity party where a young lady is assaulted by 3 or 4 young men.
And my guess is, and this goes back to Nancy's point and the general point made here about the lack of reliable data, information generally on these issues, but my guess is that more likely than not, the victim and the assailant know each other.
At the right time, if there could be some clarity that comes out of this discussion, particularly for the Department of Education, for the compliance audits, we would sincerely appreciate that. As the negotiated rulemaking, that was one of our guiding principles, to seek for clarity in the language that we came out of that and make things simpler. And this is one issue that, again, I hear colleagues speak of that help guide us in these timely warning issues, the notification issues. Because I also hear from advocates on my campus that they want a timely warning for all sexual assaults. And I don't know if that's correct or not, if that's the right approach, but I think
We've been questioned as well. We knew you had a sexual assault. Why didn't you do a timely warning? Not by the DOE, but by my campus. Right. And it didn't meet the threshold. There is no ongoing. We have the person in hand. Everything's all set. But responding back to educating the public on what exactly all these efforts are for is very helpful.
Something else I want to bring up regarding regulations is to say that the Clary crime statistics are very misleading. And I never hear that, so I'm going to say it. Clary defines very carefully what areas our crime is to be reported. I'd say well over 50% of sexual assaults that we are aware of on our campus are occurring off campus. They're student to student. They're in a house or a loft apartment or whatever. They are among people who know each other. They will not fall into the Claire statistics because they occur off campus. It's important, you know, if we want people to make educated decisions and be aware, it's important that those crime statistics reflect as much as we know about where sexual assaults occur.
I would mimic what Mike just said. That's incredibly important. And I can carry it one step further. In our university, our fraternities are not part of the official student Greek system, and so any sex assaults occurring out through the fraternities are not being captured in Cleary, as well as, you know, all the off-campus or you know, those different kind of group residences that aren't official residences on campus or officially sanctioned by the university.
And there are more students living in those locations than there are on campus.
Yep.
So it's even worse because the vast majority of the students are simply just not being captured.
If I can just speak
Go ahead.
in defense of timely warnings for a second, I think that one of the most powerful tools for change that we've seen is students taking the law into their own hands and filing federal complaints. It is really hard to file a Cleary complaint because you're dependent on your school's information to know if your school's information is correct or not. I know students who have had to, you know, trek up to some remote office and take cell phone pictures of records with their phones to make sure that, because they weren't allowed to take these records out of the office. And I think that one thing that a timely warning does is it allows people to know that they're being counted. So I think that if there's a move away from that, we really need to see an increase of Department of Education proactive investigations, because students just aren't going to have the information they need to do that work themselves.
One thing I would suggest with the timely warning is, if any changes are going to be made to that you consider carefully some ways in which to give the victim control over how the timely warning, if the timely warning is given, and how it is given. Whether that be allowing her to or him to, you know, veto a timely warning in their case, or, you know, making it more of an opt-in situation. But if what we want is, or what our concern is, that certain survivors are going to not want a timely warning, but certain survivors are, then the way to resolve that dilemma is to put the decision in the hands of the survivor. And, you know, acknowledging that there may be problems in terms of, you know, asking a survivor to make that decision at that moment in time. With these policy choices, it's rarely a perfect situation. So I just want to put that on the table as something to consider if there are going to be changes to the timely warning.
And I would also not want to see a timely warning used as a way to get information out of a victim that they don't want to share. Because timely warnings are about a threat, ongoing threat, and maybe the victim doesn't want to report yet. I don't want to tell you who sexually assaulted me, but my RA told you that this happened. I don't want them to be like, well, if you don't tell us, then we're going to have to do a timely warning, because now there's an unknown ongoing threat. So I would also not want to see them used that way either.
We got a problem with timely warnings. You're damned if you do and you're damned if you don't.
Right.
So you guys need to put your heads together and give us some advice about this. Speaking of equality, should we contemplate legislating that all Title IX violations that occur and all code of conduct violations that occur all be handled by the same process regardless of who the alleged perpetrator is, and get away from the reality on some campuses that the athletic department has their own process if the accused person is an athlete?
Yes.
Yeah.
I think it's core that all students must be treated the same, regardless of who's the victim, who's the respondent, and what their status is. I can't imagine any equality if you don't have that. Where I thought you were going, and I got uncomfortable, was that, we're talking about students, but there's also faculty and staff. And I know on our campus, the faculty will have a different process because of the faculty handbook that's developed over time. And so that's where I thought you were going. But I don't have it. I have no discomfort. Actually, I would applaud that all students are treated.
Do any of the universities represented here have two separate systems, one for the athletic department and one for the rest of the campus?
No, absolutely not.
No,
No?
absolutely not.
Okay. Some schools do.
We do have this different, the human resources process for those that are staff that might have to go through human resources hearings. We have the faculty hearing process through academic affairs. We also have crimes that occur that have no affiliation with the university, that happen on our property. The visitors, and we deal with those as well. And none of this applies in terms of administrative processes, which is obvious.
I think the mandated reporting that's evolved, or not evolved, but is in place now, really also addresses that issue. I mean, we not only emphasize with RAs, you must report, but it also, the same message is to coaches. You must report up till it reaches the Title IX coordinator. There needs to be a lot of training of faculty and staff, but I think that may be already in place.
One thing I would like to just bring up is the fact that when I hear training, I think of a 2 or 3 hour training session that we can check a box and say we've accomplished this. But I think it's more about building a culture where we're constantly talking about this issue, so that, I have a really great relationship with our athletic department, and it's not just the 1 hour training I go in, but I call coaches just to say hi and build rapport so that they know if something happens, they can call me and we can work together through the process. Because our numbers are going to go up. The more and more work you're doing on a campus, those numbers will increase. And I think that with your help to really let everybody know that that's a good thing, because people do get worried and they think, I don't want to have all these clearing numbers, right. And how can we show? And I struggle with that with parents. I do a parent orientation when the first year students move in, and I learned how to paint it in a very positive light very quickly and let students' parents know we are no different than any other college across the country. How we are different is that we're doing something about it and being proactive. And so that does reflect a higher number because students know where to go, they feel comfortable with the process. And so I think to change that public perception is huge. And that's going to increase people reporting the numbers for the campuses as well.
And Darcy, I think you can take that one step further too. We have a joint task force with our athletic department, with the district attorney's office, for that same reason, so that you do start building those lines of communication and systems approach for when those kinds of cases pop up.
And especially looking at athletes as a positive thing too. I think we so often vilify athletics, and they can be such a huge asset because just like the number of perpetrators is a small percentage of the population, same thing with the athletics. And so for the most part, athletes don't want to have that stigma. So how do we get athletes to be allies with us and not working against us?
And you've done that at Connecticut College.
Yeah. We have a really good relationship with our men's ice hockey team, which is our big helmet sport because we don't have a football team. But they have really taken Green Dot as a major initiative for their team and have really stood behind it as their mantra and have just helped us raise a huge amount of awareness around the program and really created a success.
I'd like to make the puck green? Do they make the puck green?
The NCAA regulations can't do that, but they did get Green Dot jerseys specifically for their annual game. So,
can I raise an issue? We've mentioned it a little bit here, but very often it's sort of the elephant in the room: alcohol use. We've mentioned it's not a defense. clearly, it's not a defense to the crime of sexual assault. We ought to repeat that again and again and again. But university presidents have said to me, oh, I wish we didn't have so much alcohol abuse because it leads to all these problems from an enforcement standpoint, you know, as though they had nothing to do with it, as though they could do nothing about it. But we're here about enforcement, and is it something that needs to be addressed more forcefully and aggressively, because so often it is involved in non-consensual and other kinds of crimes, sexual assault?
I think it's important that we're clear about what we mean by involved, because I think it's absolutely true that a lot of students are drinking when they, or have been drinking when they are assaulted. I don't think that the alcohol is sort of the but-for there. I think that often, because it's they're assaulted by people they know, they've been out in a social environment and there's alcohol involved. I've heard a lot of survivor stories. There is only one I've ever heard where it was really alcohol that played the definitive role, where it was, sort of the college rape story of the popular imagination, which is woman wakes up and has no idea what has happened. And this was not an ambiguous situation. She was passed out, picked up, and put into a car and driven away. So I think that we can talk about sort of training students, again, as bystanders in social situations. I don't think that if we stop college drinking, we're going to stop college rape.
Right.
I agree, because sex assault does happen without alcohol, and so alcohol is the weapon that perpetrators are using to cause sexual assault. So I think we have to be careful that when we focus on alcohol, it's not about, stopping drinking. People shouldn't drink. If you don't drink, you won't be raped, because that's not going to stop sexual assault. We need to be talking about perpetrators who are using alcohol as a way to be able to perpetrate sexual assault, and I think that easily gets confused.
And I would just want to say, too, we thought so much about this specific problem because we do find that in law enforcement, I've seen some truly awful community presentations about how to, keep safe and women's safety. I mean, that just makes me absolutely cringe. And it's a very slippery slope.
Don't drink and have a buddy, right?
Right. Well, yeah, cover your, all these things that I think are very well intentioned and extremely ill-informed. And so I'm just going to I'll read you just a brief part. In the MOU for any agency that wants to participate in the program, we put it in here because we believe so much about it. Caution shall be used when providing any community education regarding risk reduction strategies to avoid shifting the focus from the offender's responsibility to not commit a sexual assault. For example, risk reduction strategies should be framed by how the perpetrator targets a victim, i.e. their intoxicated or isolated persons, instead of how a victim's behavior allowed an assault to occur, i.e. the victim consumed alcohol. Right. That's a very important clarification to be made if you're going to go down that road. Because we don't, as the professionals in this trying to affect change, need to be perpetuating these myths.
Because those myths get in the way of some people when they investigate the cases. They're like, oh, well, they shouldn't have been drinking or this wouldn't have happened. And that gets in the way of people's investigation, be it police or administrative.
And you do have to understand it, right? If you're going to be a good criminal investigator, you need to understand the vulnerabilities, the accessibilities, and how a perpetrator makes victims appear to lack credibility. And oftentimes all of those are wrapped up in a drug-facilitated or alcohol-facilitated assault. The difference is in showing how they premeditated that, not how the victim allowed it.
Yeah, and the conversation also comes to, often we get asked, we talk to the media a lot, well, how many beers is too many in order to consent? As if there's some hard and fast one beer too many rule. There is no such thing, and again, this is an area where state laws are a giant quilt of mixed bag. It's really hard to say to people, well, in this state we have an intoxication standard that doesn't even talk about that. They talk about mental incapacity. People don't even see themselves and what we're talking about in that law. So it's really hard to just try and draw black and white in this area. And again, I think we need to shift the dialogue so that we're talking about how this is a factor in the crime, but not a cause of the crime.
Do we have model state statutes around incapacity and consent that have been put out by the NDAA, by the National District Attorneys Association, or by DOJ, or any APRI or any of those?
No, and I can tell you, I sit on the Public Policy Committee for the Oregon Sexual Assault Task Force, and this is something that has come up actually routinely, because anybody who actually spends any time investigating these crimes will soon become frustrated by the amount of consent cases that they can't take to a DA's office that they want to. You know, you're
because of the variety
right.
of different state statutes that impact it. Well, we ought to try to pull together the police chiefs and the National DA's Association and Justice and try to get them to work on a model state statute on consent. I would think in this environment it would have some political success.
Yeah.
Colorado is, I mentioned the two different subsections earlier, but it's routine. I mean, we expect almost 100% of the time it's the consent defense, but within the statutes that we have, we're able to work through that and what consent means. So I don't know that there's a model that's being proposed out there, but Colorado certainly is a workable series of statutes that we can provide through either one of those.
We'll pull some of the statutes and take.
I'm surprised there isn't one.
Yeah. I'm going astray for a second, but earlier you asked the question about where you might be able to help on the administrative side. I'd like to bring up one thing from the prosecutor law enforcement side, and it does have overlap with the university. We still have an extreme shortage of SANE programs and the ability for survivors to come forward to get SANE exams. And while selfishly that's very helpful to me on the forensic evidence collection, there's that side, but there's the well-being and safety and medical support that the survivor is lacking in getting. And I've been working really hard in establishing one in my community, and we have all kinds of...
There's not one in Boulder?
No. I know. And we are progressive, and we are educated, and we are intelligent in this area, but it becomes a lack of funds. And you can say, go get a grant, but everybody's competing for those grants. And nobody thinks it's their one job or role to provide the SANE exam. And so I have universities...
Women of America, rise up. There should be a SANE exam in every community in the country, the availability of SANE exams.
And we've started to see legislation go that way, like for Texas, and I think it was West Virginia started to have some of that state-by-state legislation that you can't discourage and or you must provide one. But the problem is you got a lot of students who are going to say they're university-based medical, so ours, and nobody's equipped to do that and help in that way, and that's often what's prompting them to report. So I still think we need a lot of work and help and funding availability and support for medical in the realm of getting SANE programs more established and accessible to our survivors, because that's a huge hurdle for us.
And the impact of the collection of the evidence and the retention of that evidence is tremendous in our field and for the hospital. So even if they don't report to law enforcement, the hospital's mandated to hang on to that forever and ever, amen.
We have Colorado legislation now that's been very proactive in saying you can't discourage, you help, you get it, and then we're sending every test kit down now. But there's only a couple, our survivors have to drive 45 minutes to 50 minutes to get a SANE exam. That's enough right there that people are deterred and are not going to drive out there. So we need more well-established and, available SANE programs.
And DOJ's done a great job, Senator, of supporting telehealth and new innovations so that you can make that available, particularly in the rural communities. So I think it's something that, we need additional push behind.
Okay, well, we'll look at that as we look at the grant funds that we're going to try to put in. It's sad to me because I was involved in establishing the first rape kit examinations in the Kansas City Hospital at St. Luke's in 1979, and that we're still talking about this. It is sad to me that this has not become...
Well, we've had programs before, but they failed because of funding issues, and it depends on, there's different models. There's your rape crisis center-based kind of model. There's your medical facility-based model, and so there's a difference of opinion and philosophy on those, but it comes down to funding.
Right. Okay.
Well, and speaking of funding, it really comes down to funding for all of this. We've just created new regulations for Clery. We have all these, FAQs coming out of Title IX. That's a lot of time and money that the universities need to be doing that. And I'm lucky that I work at a place where we have a dedicated victim assistance, service. But there are some people who are their Title IX coordinator, who are there, have many hats, doing prevention, doing response, and there's just not enough funding. And I know I watched the last roundtable. There's a grant out there, but they only can give out so much money. And I'm grateful for it because that's how I'm a standing office now, but there's just not enough to do a prevention, to do crime statistics, to do response.
Well, and we have to look, I mean, one of the things we're going to try to do as we draft this legislation is to address the problems that we've heard about, but also see if there's places we can simplify and make things less complicated, because the worst thing is to have someone in your job that feels they are so overburdened by filling out reports that they don't have time to check to see whether the underlying policies are taking root and whether or not they're really making a difference in terms of establishing protocols and processes that are supportive of victims. And, you know, this is an area we can definitely over-legislate because it sounds good and we want information. And the saddest part is a lot of the information we demand, there are very few people that actually consume it. And that's really a waste of time.
Yeah, that's a large concern, is to have mass quantities of reports and not have that information. And, you know, I think that having the funding there for the crime statistics is so important, but as a prevention person, I'd be remiss to say that that's where we should be throwing our money, because we can be doing a lot of work around prosecution in the criminal justice system and the judicial process, but how wonderful would it be if there wasn't that problem? And so I talk to students all the time about culture change. You know, it takes time. It's not an overnight process, but it is doable. Pick any type of cultural aspect of our community, and we can talk about how it's changed over 30, 40, 50 years. But I truly believe that we can work with college students to then become the future jurors and the future prosecutors and defense attorneys, so that they're changing that culture overall. And I think that it's a challenge that we're waiting until college to be talking about these issues. These things need to be coming up in elementary school and middle school and high school, because when students get to us, they're 18 years old and have a set ideas of how to treat people. And we can't just undo that in a 45-minute orientation program. So how can we change that culture from when they're 5 and learning about consent because somebody's tickling them and not stopping? And so they're learning, well, if I say no, it doesn't matter anyways.
Right.
So how can we change that? And personally, I think is where the money should be going.
Right. I'd like to echo that sentiment. It's one of the strong urges I have to share with you that we really are dealing with people who have been socialized for 18 years on the gender roles, on respect, on civility, on differences that are still present of boys will be boys and girls need to be polite. And it's very, we can be reactive, but I'm with Darcy on that. Let's get the education in there sooner. Let's get it more pervasive, and let's get it to a place where the equality starts the conversation much earlier.
Is there anything else that we haven't talked about today that any of you feel we've skipped over that we didn't? It's interesting because I had a list of questions, and as I look through them, we've covered almost all of them just in the natural course of talking about the things we've talked about in these 2 hours. Is there anything that we've neglected to address that we need to bring up before we finish today?
I guess I'd just like to say, kind of building on this discussion of prevention, that enforcement is also really good prevention. And if we're going to talk about what we're going to require of schools, we need to make sure that someone's holding them accountable too. That also circles back to our conversation about money, because the Department of Education needs to be big enough to be on the ground actually conducting investigations to identify the gaps between what they can see on paper of a university's policies and how survivors are actually being treated.
On that regard, I would encourage a collaborative process with the Department of Ed and the Office of Civil Rights rather than an adversarial process. And we've been exposed to a voluntary compliance reviews that then were crafted in reports as something else. So I think if you want compliance, if you want enforcement, it has to be a different flavor to it, so to speak, to encourage compliance through training, through education. As it stands now, there's a fear that if you call the Office of Civil Rights or you call the Department of Ed for guidance, you're waving a red flag, then the focus then becomes on you in terms of resolving a problem.
Sorry, I have to respectfully really disagree. I'm on a campus where the Department of Education came in, identified a series of violations, and said, sorry, we're not going to find them out of compliance. That's just not what we do. And I think that that's one of the reasons why we're seeing today is Title IX's 42nd birthday, and why we are still having this conversation, that schools know, just as perpetrators do, that they're never going to be held accountable. And that does feel in some ways very gendered to me, that we are expected to be here as good, forgiving women and give perpetrators and schools second chance after second chance after second chance.
Well, we're working on, I think that there's value to both points of view. I think there's value to cooperating, but then there's also value to bringing the hammer down. And we've got to figure out, I mean, if no school ever thinks the hammer is going to come down, then that's also a problem. And frankly, we've talked a lot about the statute, that the only real penalty that they have is to remove all federal funding, which we all know is totally unrealistic and never going to happen. So we need to have some kind of middle ground of a problem. They're adamant about wanting to stay with the voluntary compliance program. I've got no problem with a voluntary compliance program with maybe a first offense. But if you're back on that campus and they've not kept their end of the bargain, they've not done what they agreed to do, then there needs to be something other than an idle threat. And I don't think they have that right now.
And the hammer has to be something that doesn't punish students who are, after all, potentially the victims. So to have a penalty that is, in effect, a nuclear option without any other kinds of graduated responses, and also to have the penalty hit the people whom you're trying to protect and trying to give those rights of equality to, doesn't seem very smart either.
It's hard.
It is, to kind of follow up on both the enforcement and the technical assistance and the training that we were talking about earlier, that, one good way to one good place to put our money as the federal government is to require training from not only law enforcement or, the sort of frontline first responders, but also, those trauma-informed interviewing techniques should also, every Title IX coordinator on campus should be required, and that training should be provided by the federal government. It doesn't have to be provided by, staff of the Office for Civil Rights. It can be provided by, say, a technical assistance provider who is identified by OVW, by the Office on Violence Against Women in the Department of Justice, which is what they do with the campus grantees. There are a number of different ways to do it, but the training should be as uniform as possible, and therefore it should come, it should be controlled at a fairly detailed level by the federal government, and should be required. And you also deal with the funding issues, because if the federal government is providing that training, then schools don't have to come up with the money to provide it themselves. And, from my perspective, that's part of the way that you get these various messages and information about multiple goals, and the fact that there are Title IX rights as well as the right to be free from crime and things of that sort.
Right.
I agree with Nancy, and something that in terms of the administrative process that we've discussed, I'd really recommend looking to the Association of Student Conduct Administrators for best practices. I mean, I recognize clearly there are outlier institutions. There are institutions not doing the right thing.
But there's a lot that are doing the right thing.
There are a lot, and I would look to the association that provides leadership.
Okay, good suggestion.
For my final comments, I just want to touch base briefly on the prevention side of it from a different perspective. I do believe that many of the issues that we're talking about today and dealing with do have an enforcement answer to a point. I acknowledge that law enforcement isn't going to be the right answer for everybody. However, when you break from the traditional model of law enforcement and you start providing an environment that encourages reporting and therefore identifying serial perpetrators and providing that information to our DAs to prosecute those offenders, that is a form of prevention. And it will have an impact on our college campuses because we are not only sending a message to victims that they should be heard and what happened to them is important and will be taken seriously, we're sending a message to offenders.
That's right.
That they can no longer keep people silent in the same way they have before. And I do believe if we focus, no matter how you feel about law enforcement, if we focus on fixing some of the issues with our response right now to this, some of these other issues will be affected in a positive way.
I think I love you.
Ditto.
I think all the prosecutors are going, yes, Detective Carrie Holt.
And by the way, I think it is, very interesting that you have kind of reworked the traditional law enforcement model. And one of the things I think we need to do is we need to figure out a way to make that model Title IX compliant.
Yes.
And if we could do that, I think we might be onto something that could have a real positive impact on empowering victims and ultimately holding perpetrators accountable, which is, what we want to do. First, empower victims and take care of victims, but second, hold them accountable. And I know right now it's not Title IX compliant. I've already talked to the White House about this challenge, and I think we're going to try to get our heads together and figure out if we can somehow legislate a way to make that particular model Title IX compliant. And it's a little tricky because of the reporting stuff, but I think it might be worth it.
Yeah, well, we have, and I apologize if I said this already, but we have over 40 campus law enforcement agencies sworn that have reached out and said, I want to do the right thing and I want to do this. And we have to tell them right now, you are amazing and that's so great and I'm sorry. So I think it's a positive thing that they're reaching out. It's an unfortunate answer that they can't provide the model.
Well, let's figure out a way that we can make it Title IX compliant, because that's one of those things that technically it's not compliant, but I think what you're doing embraces what we want to see happen within Title IX. So we ought to figure out a way to get that done.
Great.
I think we're in a better place with Title IX after the FAQs came out.
Right.
I just want to give OCR credit for having done, from my perspective, acknowledging that there is a wide diversity among how well schools are handling this issue, that it might not be enough. What we set up was this three-path approach where you had privileged reporters and you have confidential reporters and then you have responsible employees where their confidentiality is ultimately the decision of the Title IX coordinator. But the confidential employees, that middle category, is now based on the judgment of the school. And so the school could not identify anybody, including people who are sort of very obviously should be confidential employees. They can refuse under this system to identify them as confidential employees. And so that might be a place.
Well, if you hear of a school that's done that, make sure and let me know, because I'll have them as a witness at a hearing. Because that would really be bad if they tried to take mental health professionals or health professionals and tried to...
Right. No, I'm not talking about those folks, because those folks have privilege based on state law. I'm talking about the folks like Women's Center directors, like I used to be, who do not have privilege based on counseling license, for instance, but are likely to be considered by students as being someone who I can go to confidentially, and my report will not be automatically advanced to the Title IX coordinator. And part of the idea of you have options is that you have options.
Right.
So there might be a way under Title IX to retain the sort of enforcement idea, but still give options.
Right.
But that may not be advisable to leave that entirely up to the school to determine, and to actually identify some folks on campus in certain roles that should be confidential, regardless of whether they have privilege.
In this model, the only person who would decide whether someone was confidential or not would be the victim.
Right.
It wouldn't be the schools.
And the hang-up that we've seen is that for this to truly be effective, because of course due to time we didn't talk about the other side of the program, which is the investigation, you would have to make your campus law enforcement not Title IX reporters.
Right.
In order for this to truly be effective so they could identify serial perpetration. And I think a lot of people have a hard time saying that a campus law enforcement who's employed by a campus isn't a responsible person.
Right.
So that's a departure. Yeah.
Well, we've got to work on it. I want to thank all of you. It's been terrific.
Thank you all.
We've learned a lot, and I think we are better informed than when we began, and you all are doing tremendous work, and I really appreciate you taking the time and traveling to be here today and helping us with this. And please continue to communicate with us especially once the legislation is drafted and you have a chance to look at it. We will tell you with certainty that a piece of legislation being drafted does not mean that it's going to look anything like that when it's finished. So there will be plenty of opportunities, yes, right, plenty of opportunities to shape it and change it and tweak it and amend it, and we will look to you for guidance on the best ways that we can get the very best package possible to get at this problem that I know that you all work at every single day. Thank you very much.
Thank you.